Hi, everyone. Sorry, we're getting started. Thank you so much for coming, and thank you for joining us for this really essential conversation, an exploration into the ever-evolving landscape of reproductive rights and the deeply troubling ramifications that have emerged since the overturning of Roe v. Wade last year. In the wake of 2022's Dobbs decision, it is now safe to say that a shadow has fallen on the healthcare system of the United States, where abortion providers and their patients find themselves navigating indeed very treacherous waters, fraught with criminal punishment and civil liabilities in tandem. But let's be clear, this is not a recent phenomenon. It's part of a long-standing pattern of injustice that has disproportionately affected pregnant people, especially women of color. Since 1974, the Clayman Institute has been at the forefront of conducting research around topics related to feminism, gender, race, and sexuality, and as such, we feel that we are the place on campus that needs to keep this conversation going, needs to keep monitoring, needs to keep publicizing what is happening, and think through possible solutions, whatever they might be. Our Clayman Conversations series, which is this part, is our attempt to bring cutting edge and current feminist thinking onto campus and bring it into dialogue with the big issues of our time. And this, of course, is may well be the biggest. This is the 10th of our Clayman Conversation series, which is very exciting to us. It's a nice anniversary to have. But it's also, of course, it's the second one we've done on the question of abortion care post-Dobbs, and we will keep doing that for as long as it takes. If you are interested in fellowship, internship opportunities, events, or just our research at the Institute, please feel free to visit our website, which is just gender.stanford.edu. Lastly, I want to invite all of you to mark your calendars for our next event in this series, scheduled for November 14th at 3:30, which is a Zoom event. It's titled Why Land Back is a Feminist Issue, and we'll delve into the relationship between gendered violence and the dispossession of indigenous lands, the politics of gender in indigenous land reclamation, and why land back is a feminist issue. So tonight, we confront a system that has for far too long infringed on the personal autonomy and violated the principles of bodily sovereignty. Most importantly, we're hoping that our wonderful panel of speakers will be able to illuminate some pathways towards a future where safe reproductive care and bodily sovereignty are not just aspirations, but in fact an unassailable standard for all. Guiding us through this critical dialogue is our esteemed moderator, writer-in-residence Maura Donegan, whose work at the intersection of gender, politics, and the law has made a profound impact. Her insights and dedication to feminist issues are nothing short of inspiring, and we're really privileged to have her guide us through tonight's event. Welcome, Maura. Welcome to the panel. Thank you so much for being here, and thank you all for being here.
Thank you, Adrian, for that lovely introduction, and thank you to all of you so much for being here. I think this is going to be a wonderful conversation. We have some of the most brilliant people working in this area here with us today, so I think we're really privileged to hear from them. So as Adrian was alluding to, we are in a moment when the legal status of reproduction is changing all around us. Rights are newly contested, and all manner of reproductive health care, from birth control access to abortion to prenatal medicine and emergency interventions, are newly precarious and subject to different and intensified forms of scrutiny. The reality, of course, is that little of this is new. Agents of the state, from healthcare providers to social workers to child welfare or family regulation agents to police and prosecutors, have long used pregnancy status as a pretext for curtailing rights and made punitive interventions ranging from arrest to surveillance to custody loss to benefit withdrawal on the basis of conduct by pregnant persons that would not warrant punishment if committed by those who were not pregnant. What a person is entitled to and what she can be punished for seems to change dramatically the moment a little blue line appears on a pregnancy test. For pregnant people and for those of us who might one day become pregnant, the landscape of freedoms and risks, rights and liabilities can appear as a treacherous terrain. But there are perhaps no people better equipped to help us map this territory than our three panelists tonight. I could spend the whole evening extolling their virtues because I'm here with some of the most formidable and intimidatingly accomplished women in America tonight. So when I read their bios, I want you all to resist the temptation to compare and despair, because these are not people who you can reasonably compare yourselves to. So I will start with Kiara Bridges, who is a professor of law at UC Berkeley School of Law. She has written many articles concerning race, class, reproductive rights, and the intersection of the three. Her scholarship has appeared in the Harvard Law Review, Stanford Law Review, the Columbia Law Review, the California Law Review, the NYU Law Review, and the Virginia Law Review, among others. She is also the author of 3 books, Reproducing Race, an Ethnography of Pregnancy as a Site of Racialization from 2011, The Poverty of Privacy Rights from 2017, and Critical Race Theory, a Primer from 2019. She's a co-editor of a reproductive justice book series that is published under the imprint of the University of California Press. I'd like to also add that in addition to being a law professor, Kiara Bridges also has a PhD in anthropology. And am I right that you're a ballerina? Is that, yeah. See what I mean? Like, Arin Carmon is a senior correspondent at New York Magazine, where she covers gender, law, politics, and more. She is the co-author of the New York Times best-selling book Notorious RBG, The Life and Times of Ruth Bader Ginsburg. Her next book, currently in progress, will be Unbearable, Being Pregnant in America. Thank you, Arin, so much for being here. It's really wonderful to see you. And Michelle Goodwin is the Linda D. and Timothy J. O'Neill Professor of Constitutional Law and Global Health Policy at Georgetown Law. She is also co-faculty director of the O'Neill Institute for National and Global Health Law. Previously, she served as Chancellor's Professor at the University of California, Irvine, where she was the founding director of the Center for Biotechnology and Global Health Policy. Professor Goodwin is the author of Policing the Womb, Invisible Women and the Criminalization of Motherhood. She's also host of the popular podcast On the Issues at Ms. Magazine. Michelle, thank you so much.
Thank you.
So I think it might be productive to just start with a definition of our terms, because when we talk about criminalizing pregnancy, we're talking about a lot of different state interventions in response to a lot of different pregnancy outcomes, most of which are not abortion, right? So Michelle, could you give us a 10,000-foot overview of pregnancy criminalization?
First, I want to thank you and colleagues for hosting us. It is a pleasure and privilege to be on the stage with you and also my colleagues here whom I admire and adore so much. And when we're talking about criminalization, I think if we're doing 10,000, 30,000, it's important to just level set in terms of surveillance itself. So we can think about Dobbs as introducing new forms of surveillance, or as if there were surveillance just leading up to Dobbs. But the reality is we could date back centuries in this country, and there was surveillance. The earliest American laws related to American slavery and the surveillance of reproduction. And that's, for so many people, so surprising. The earliest American laws that determined the status of a child as being accorded to the mother. There was a reason for that. That's because it was capital that was associated with that. Thomas Jefferson, former president, famously wrote to another politician, John Wells Epps, that it was really unwise to just think about stocking your plantation with just men, because girls and women were where the profit was. And he wrote explicitly, directly, that's because they turn a profit every year or two. I could just talk through virtually every area of the earliest of American laws as being connected to slavery, as being connected to policing how girls and women reproduced. And those were forms of surveillance. Even when we think about the Texas SB 8 law itself, that was the early part of the term. So we start off the term with Texas SB 8 being upheld by the Supreme Court and shadow docket, and the end of it with Dobbs. But it has a surveillance component to it that allows for citizens to be able to litigate against individuals who aid or abet individuals with terminating a pregnancy. And immediately what came to mind for me was the fugitive slave laws, because where it comes from, federal law that allows individuals to search after and apprehend people who are aiding and abetting people who are seeking to escape from slavery, as well as to capture people who have escaped. So when we think about criminalization is an important part of it. It happens to be surveillance. And one last point, and then I'll talk about this in a way in which people are sort of thinking about in terms of Dobbs. But if we even think about the earliest of police in the United States, they were the Slave Police Patrol, and the badges look just like the badges today. So we have to understand sort of policing pregnancy is not new. It's something that dates back a long, long time, and policing for profit, et cetera. But we could also think about it another way, right? And so that's one version of thinking about black women as the canaries in the coal mine. But there's another way of thinking about it. In the 1980s and 90s, work done by Dorothy Roberts, Killing the Black Body, which captures so much of this, and also articles that she wrote in the Yale Law Journal and Harvard Law Review, about this painful intersection, right? It sort of comes together of mass incarceration and mass incarceration associated with the drug war, and also this sort of contempt against poor mothers, right, as welfare queens, coming together in this kind of bold and horrific way, leading to the hyper-surveillance of poor black women as they, interestingly enough, seek prenatal care. So a lot of the policing that we see with regard to, in the histories of it, with regard to pregnancy, don't necessarily relate to abortion. They actually relate to black women just wanting to have health care. And that being a source of surveillance, of punishment. Research in the 80s and 90s revealed that, if you're a black woman, you went in for prenatal care and you told your story, and a story that might have involved having used a drug during pregnancy, you were 10 times more likely than your white counterpart to have law enforcement called on you, your children taken away from you. In the 80s and 90s, there were black women who were dragged out of hospitals. Medical University of South Carolina, one example. After being encouraged to come in for prenatal care, billboards all around, come in, you're poor, you need prenatal care, we want people like you and people who may have histories of drug addiction and use. And then only to be part of a dragnet where literally medical providers are seeking to punish these women as they come in, encouraging them to come in, but only for the purpose of turning over their private patient information to law enforcement, and it being explicitly racialized, right? So in the Medical University of South Carolina case, you got like dozens of black women who are dragged out of hospitals, shackles and chains, their medical information having been turned over to law enforcement. And we know that it's racialized because it's only black women, with the exception of one white woman.
She had a black boyfriend.
Exactly. Nurse Brown writes on her medical chart, lives with Negro boyfriend. So this gets you in. And the other.
Can you just share what year this was?
This is like 1989, 90, 92, right? Like this is not lives with Negro boyfriend in 1942, yeah. Right? And so anyway, when we think about these histories of surveillance, they're written in many ways into the soil. And one last thing they'll say before you move on with other questions is that when we think about some of the places where this policing has been most prolific and where we see the policing of abortion, you could draw a Venn diagram and you can add in one other, and that is the Confederacy, American slavery. Like Dobbs comes out of Mississippi. And to give you some sense about how those histories, what's old is present, is that you think about something like the 13th Amendment, 1865, abolishing slavery and involuntary servitude. And to be clear, the abolition then is not just about, this bucolic setting, with lush green fields and little puffs of cotton. The abolitionists are working against the sexual subordination of black girls and women. You've got Charles Sumner, who's nearly beaten to death in the halls of Congress, only days after giving a speech explicitly stating the rape of black girls and women. It is the largest drum cry to end American slavery. They are writing about going south and knowing about the cases of little black girls committing suicide, jumping off of barns and off of houses because they know what this future is for them. And so in 1865, we have the abolition of slavery and involuntary servitude. It's not just about picking cotton and cutting the sugar cane. It's about ending this pernicious system that demands sexual servitude and reproduction of black girls and black women. But in Mississippi doesn't ratify the 13th Amendment in 1865. It ratifies it in 2013. So then when we think about what has been part of a soil and practice in terms of surveillance, subordination, not associating rights with certain groups, it's been baked into the soil for so long. And you think about so many of these states, liberation has only been something that's been an external source imposed on, whether it's been through Supreme Court, executive orders from presidents, or Congress. You won't find a narrative coming from these places that says, oh, we recognize what we were doing in the 1600s, 1700s, 1800s, and 1900s, and how awful this was, right? It only comes from the outside in, and we see this kind of policing and surveillance that continues to this day.
I'm so glad you bring up the connection of this tradition of surveillance, right, to try and embed this very deep in our history. So I love this example also of the hospital in South Carolina. Can you remember the name of the hospital?
Yeah, Medical University of South Carolina, a state institution.
And this is a place where people who maybe were indigent, people who were poor, and overwhelmingly people who were black, who were being encouraged to come in for the prenatal care that they might otherwise not be able to afford. And were being surveilled there for drug use.
That's right. That's right. And what's interesting is that that's just an example. It was happening all across the country. And, you know, empirically, what may be confusing for some people is they may say, well, that's just because black women were more likely to use the kind of drugs that led to this. No. There's no distinction in terms of the rates of crystallized cocaine use between white women and black women, none whatsoever. Across these various categories, it was just very explicit that there was one category of people that they were looking to police and to punish. And it happened that in that specific setting, they were looking at crystallized cocaine, but were making exceptions for all of the white women who were coming in who used crystallized cocaine, otherwise known as crack.
And I would like to pause for a moment on crack, because Michelle, your work has shown me very clearly the way that the terror fomented in the media and by some public health authorities about crack cocaine use during pregnancy and this like very racialized fear of the children who would result was used to further the criminalization of pregnancy. Could you tell us a little bit about the crack panic?
Yeah, that should be the title of a book too, Crack Panic, right? In 2003, the New England Journal of Medicine and the Journal of American Medical Association said we'll no longer use the term crack mom, crack baby. We recognize now it doesn't exist, right? But so many lives had been harmed leading up to this point. Here's something else that's really important when I think about, you know, the institute that brings us here, which is that there were two scholars, Dr. Hallam Hurt, who's at Penn, and Dr. Claire Coles, who's at Emory. And these are women who had devoted their careers to investigating maternal-fetal interactions across a number of drugs and substances, nicotine, alcohol, methamphetamine, powder cocaine, crystallized cocaine, all of this. I mean, decades of research. These were the pinnacle, really, of experts. And they had been telling reporters from the New York Times, from Rolling Stone, from the Wall Street Journal, from Wash Post, you're getting it wrong. You're just getting it wrong. Let us tell you about nicotine. Let us tell you about alcohol. what you're claiming that you're seeing and the source that you can't really name is not true. Reporters were writing that, these babies born from mothers who had used crystallized cocaine during pregnancy, that they don't want to be touched, that they can't look in the eyes of anybody, that they will grow up to be pariahs of society, all of these kinds of things. And they said, well, this is wrong based on our decades of research. We can tell you that this is not right. And I've interviewed them both several times, and they told me that they were ultimately blacklisted. Reporters stopped calling them because they were not telling a story that was sexy. The story that was sexy is tell us about how bad black women are. Tell us about black women who are dredges of society, who are welfare queens. Tell us about these women who are so irresponsible that they don't love themselves, they don't love their kids. And these were narratives that they said, this just isn't true. But to give you some sense of the kind of, again, these racial arcs that we just are uncomfortable to talk about in our society, if you think about the early history of lynching in the United States, part of the terror associated with lynching also had a lot to do with the anatomy. Let's burn the body and cut off pieces of the anatomy. Some strange fixation with penises. I really don't understand it, but really, where people, it was like part of the narrative, noted in the news, the desecration of. Well, it's interesting. You can find these articles in the, Rolling Stone and others, right, about how these babies born from black mothers who've used crack will have distorted genitalia. It's like, who's thinking of these things? That like and it's not true. It's not true, and that, and things about their brains and things about their intestines. But one other thing that I should mention, because I started with slavery, is to also say that eugenics is also this point of surveilling in our country. And it ends up being wrapped into Dobbs as well through some misframing and inaccuracy through Justice Thomas, who has been inaccurate about a number of things in his jurisprudence. But that's important too, to just think about another version of a racialized arc of policing in the United States. And this is one that we've forgotten about considerably in our country, because around the turn of the 20th century, there are about 30 different categories of whiteness in the United States, which would seem surprising to a lot of people, because it's kind of like there's just white. But that wasn't the case. So there's a deep policing of whiteness, and that was America's history with eugenics. You had to be the right kind of white. And if you weren't the right kind of white, then this could mean that you were subjected to compulsory sterilization laws. And in 1927, in a case known as Buck v. Bell, the United States Supreme Court upheld, in an 8-1 decision, a uniform eugenics law out of the state of Virginia, which allowed for forced sterilization of people who were considered to be socially, morally, physically unfit. Yeah.
So I'm glad you bring up both whiteness and surveillance, right? Because I think there is a way in which pregnancy criminalization has been furthered, not just by who is subjected to intense scrutiny of their pregnancies and of their behavior during pregnancies, but also who has the opportunity to avoid surveillance. And Kiara, I think this might be a nice point to bring you in on, because your ethnographic work for your doctorate was on welfare recipients who were subjected to additional surveillance during their pregnancies under the pretext of justifying any kind of continuation or withdrawal of their benefits. Could you tell us a little bit about your research?
Well, actually, it's interesting. So my dissertation research, which ultimately became my first book, Reproducing Race, was based in a public hospital in New York City. I call it Alpha, but if you've lived in New York for more than, 2 minutes,
you know exactly.
Alpha. And it's in the obstetrics clinic of this hospital. And I was just there to sort of document or to observe way that the black letter law is materialized on the ground. I was really interested in the difference between law in the books and law on the ground. And what I saw was, and again, this was just a site where people who are pregnant come, they are indigent, most of them. You said welfare recipients. These are actually, many of them didn't receive public benefits in the form of cash, but the public benefit that they received was Medicaid. So they're all except one during my research there were Medicaid reliant. Do I need the microphone? It's not working, okay. So they all were Medicaid reliant, and they were there just to, they were pregnant, they wanted to have healthy babies, they wanted to have a healthy pregnancy, they were there to receive prenatal care, and the materiality of this space was just one of punishment. And our conversation today is framed as one about criminalization, but the criminal legal system is just one avenue by which people are punished in the U.S. And there are myriad other forms and institutions that punish. And in this hospital, I was observing punishment, hyper surveillance, how easy it was for people who, again, they just showed up to get prenatal care, could be swept into other punitive institutions like ICE. Their immigration status would be investigated, like the child protective system or the family regulation system, right? How they would be threatened with losing custody of their children for simply being poor and daring to want to be a parent. And so these were people who were disproportionately people of color. These were people who were all indigent. These were people who had sort of various intersecting axes of vulnerability. And so the system of healthcare that we have erected in our country, is a two-tiered one, where if you have a modicum of class privilege, you will have private insurance. You won't need to rely on Medicaid, so you'll have commercial insurance. And that sort of commercial insurance card, that Blue Cross Blue Shield, that Anthem Blue Cross, that buys you an exit from
It's status.
Yeah, absolutely. Like you would not go to this hospital with your commercial insurance because this hospital was the site for poor people. It was a poor people's hospital. And so in these other hospitals, I'm actually conducting research for another book project right now. And this hospital that is the site of my current research is fancy. They offer concierge service. When there's a wait, if it's more than 10 minutes, you have a 3:30 appointment, it's 3:40. The office manager will come out and say, I'm sorry, would you like some water? Your midwife is running behind, right? Things that are just unfathomable in the public hospital where I did my first research. And so I can tell you that it doesn't look like a carceral institution in this private hospital. It's not punitive in its effect. It's not punitive in its intent. And so I say all of that to say that one class privilege, which is disproportionately enjoyed, right, by people who have race privilege in our country. Class privilege buys you an exit from carcerality, buys you an exit from punishment, buys you, and also we just know just better health care.
Well, that's Skinnerville, Oklahoma, isn't it?
Yeah, absolutely.
Right? Like, this case, 1942, unanimous decision. But interesting, the law itself provided that if you were a chicken thief, petty thieves, you could be sterilized against your will. And explicitly in the law, not if you were a white-collar criminal, not if you embezzled millions from people, not if you stole their funds out of the bank. You were not subject to this law of taking away your reproductive future, only if you happen to be engaged in petty crime.
Right, yeah. And so the analogy is, right, you're engaged in the same activity. Imagine a low-income person and someone with commercial insurance, right? You're engaged in the same activity, whether it is, taking prescription pills, whether it is snorting cocaine, whether it is, indulging in some sort of substance that has been controlled. When you're in a public hospital, you're much more likely, right, to be, first of all, be screened for drug use, You're much more likely when there is a positive drug screen for your healthcare providers to snitch on you, right, and to call the cops and to call Child Protective Services. You're much more likely to be swept into these carceral institutions that you then have to struggle to find some sort of way out. Again, without assistance, right? Because once you have an open case, it doesn't mean that you then get drug treatment. It doesn't mean that you then get, a room in a facility that will help you with your drug dependence. It just simply means that the state is monitoring you and withholding custody of your children from you until you get better on your own as a low-income person. Meanwhile, a more affluent person, same substance use dependence, same substance use disorder, same sort of behavior as a low-income person, much less likely to be screened for drug use in the first instance. If there is some sort of screen, if there is a confession of use, your provider is much less likely to report. I mean, it would be like a violation. It is a fiduciary duty, right? Doctors and patients have a fiduciary relationship, so it is a violation of a fiduciary relationship for a doctor to turn to another entity, the cops, the state, to then report what their fiduciary is doing. So all of this to say, you have two different outcomes when there is class privilege versus when there is indigence, and that's how we avoid carcerality and its use.
I am so glad that you bring up the undermining of the fiduciary responsibility between doctors and patients, because that is, of course, now something we're seeing a lot of fear and quite justified fear about post-ops, right? People who have maybe taken mifepristone or misoprostol tablets, perhaps in a ban state, who wind up in the emergency room because they are worried by the amount of bleeding that they're experiencing, who in a desire to have a healthy outcome, who in a desire to preserve their health, preserve their fertility, preserve their families and their ability to stay around to take care of their other children, will tell the truth to their healthcare providers and will be endangered and betrayed and punished by these providers who are often, merely trying to avoid carceral responses to their own conduct, right? And this, I think, might be a great moment to turn to Erin, who has been reporting in Alabama about pregnancy criminalization in the post-Dobbs era. Erin, could you tell us about what's changed and what's the same?
Sure, and it's such an honor to be on stage with people that I've learned from so much. Perhaps one pivot point from two people that I've learned from who I've seen cited in your work as well, and we've already mentioned Dorothy Roberts. When I profiled Dorothy Roberts for New York Magazine a couple of years ago, it was a year and a half ago because it was right after Dobbs, and it was about how Dorothy Roberts was calling attention to the ways in which reproduction was being policed by the state, apart from the mainstream abortion rights discourse, which was always about, what is the Supreme Court going to say about equality or privacy? So apart from even as a way as journalists are used to covering the legal conflict around abortion, Dorothy Roberts was enriching and calling attention to, enriching the debate, calling attention to what was being left out. And one of the things that she said to me in that interview, one of the interviews that we did, was that you mentioned black women as the canary in the coal mine. She said that these are policies that are tested on black women, and they fan outwards to white women. Now, of course, it's not just a testing ground, because the flip side of eugenics, negative eugenics as policed on people who are considered undesirable by white patriarchy, is to, is that me? Positive, quote unquote, this is huge quote unquote, scare quotes, positive eugenics, which is about ensuring that the quote unquote right people acquiesce to the dictates, have white babies, putting it up, married white women, not providing competition in the workforce for men, reproducing on terms that are considered acceptable terms. So the abortion bans understood as that as well, in terms of ensuring even the women that we consider to have the most choice, that they have less choice. And I actually didn't understand the tentacles of this until I read Professor Bridges' piece on whiteness and the criminalization of pregnancy in Harvard Law School. Because I was in Alabama, and there were a few things that I was doing in Alabama for my book, Unbearable. which I really enjoyed telling every person in Alabama what it was called, just to see what the reaction was. And in general, because you always see people flinch, like they're like, okay, I get what that's about. So Pregnancy Justice, which used to be called the National Advocates for Pregnant Women, has been counting these incidents that we're talking about for many years. And they recently updated their counts of people who were arrested for charges in connection to the pregnancy. So I said I was going to cite two people. The other person is Lynn Paltrow, who is the founder of the National Advocates for Pregnant Women, now renamed Pregnancy Justice. And one of the insights, I interviewed her, she just retired after 20 years, I believe, 25 years of doing work when it was really lonely in her corner of the legal world. And part of her insight was that the kinds of criminalization that we're talking about is a way to enact fetal personhood in the law while abortion is still technically legal. Now, everything we're talking about took place when there was still a federal floor for abortion being legal in the United States. So obviously imagine what happens when that is no longer the case. So this was already something that the different arms of the state and all of the ways it shows up were able to enact on people's lives when there was still a quote-unquote right to privacy on paper. And so Alabama, in the Pregnancy Justice Report, they counted, I believe it was around 1,300 cases of arrests relating to pregnancy. And Lynn Paltrow has always pointed out that this is conduct that would not be criminalized were that person not pregnant. So it is not illegal to use drugs. Possession is a different charge. Unless you are pregnant, you forfeit your constitutional rights, your privacy rights, your autonomy rights when you become pregnant. A way in which, again, fetal personhood has become, was smuggled into the law before it was allowed to be federally. And of course, as you've both observed, in 2013, the Alabama Supreme Court made it explicit by saying that their chemical endangerment law, which was passed in the name of protecting children from exploding meth labs, that this should be applied prenatally as well, because a fetus is also a child, and where the law says child, it should also be fetus. So this is one reason why in the Pregnancy Justice Report that came out recently, again, it's tracking all arrests from 2006 to 2022 to basically the day before Dobbs. Alabama had 45% of the cases. And I discovered in the course of my reporting that 150 of the cases, which is actually roughly 1 in 10, more than 1 in 10 of all of the cases in the entire country that they were able to document, this is just obviously what they could document, originated in one county, Etowah County. The county seat is Gadsden, most famous for being the stomping grounds of Roy Moore. A county of 100,000 people accounted for 150 arrests of pregnant people over this time out of 1,300 that they counted. And interestingly, this county is, compared to Alabama at large, disproportionately white. And the women that I was interviewing, some of whom are pregnancy justice clients, are white. And in fact, the one that I spent the most time with is middle class. Her father's a lawyer, her mother's a nurse practitioner, was working in the hospital where 6 days after she gave birth, she was arrested for having had a positive drug test at her 8-week appointment. So her provider didn't report her, but the hospital pulled her records and arrested her. Etowah County also has had for a long time imposed bail conditions on pregnant people that it did not impose on anybody else, even felony murder. $10,000 and a spot in rehab. And in a very Kafkaesque twist, you have to have a negative drug test to enter rehab. Now, where is the place where many people access drugs? Jail. In the case of this woman, Haley Burns, that I interviewed, she actually tested positive because she started using drugs in jail out of despair, because she spent months in jail because she could not come up with $10,000 and a spot in rehab. And then the local bail fund wrote a check for her, thanks to some interventions from activists, and they would not accept it because they said that she needed to be able to go to rehab, but she needed a negative test, drug test, to go to rehab.
Ironic.
Now, I want to just draw attention to the fact that she's bleeding in in inhumane conditions in a hospital. Anybody who's given birth or been around someone who's given birth knows that 6 days postpartum, your body is a war zone, okay? You're bleeding, you're a mess of hormones, you're at very high risk of postpartum mood disorders, you're physically very vulnerable. Her boyfriend is showing up at the jail with panty liners and adult diapers and supplies for her, and they're refusing. She's being forced to bleed through her clothing. She's sleeping on the floor.
Which can also be an infraction, if you, anyway.
Yeah, so obviously not conditions that any person should be in, but especially not postpartum. She's obviously separated from her children. There's a separate civil DHR, they call it, procedure in Alabama. And so you think about, the baby has already been born. They kept him in the hospital for monitoring. What fetal protection is being enacted when somebody already has had their baby and they're spending months in jail separated from them at a time in which, mother-baby or parent-baby bonding is very crucial for attachment after birth? The best thing for this baby is his mother being put in jail, according to the state. And so how should we think about what their actions are here? And by the way, we talked about prenatal care. I wanted to read this quote that I found so interesting from the DA. So there was complaints that people who were pregnant in jail were not getting to go to their prenatal care appointments. And the DA Willoughby said, "I don't think you can honestly say a mother that is so addicted to dangerous drugs and is choosing to use them during pregnancy is overly concerned about her prenatal care." And then when the negative attention to these bail conditions forced them to reduce the dollar amount from $10,000 to $2,500, he said, "The newly imposed bond conditions now put everything back in the mother's hand. The same individuals charged with choosing dangerous drugs over life." So it was when I read your analysis that I realized that, and also hearing about how they were treated in the court system when they tried to protest, they were punished more harshly. When they pointed out all of the procedural unfairness, it was turned against them. The fact that she had a negative drug test at the time that she was arrested was irrelevant. It is because it is about policing the boundaries of white women who are expected to reproduce in a socially sanctioned way. And so it's punitive, it's meant to be deterrent. At the time that she was in this little county jail, there were 3 other women who were there for pregnancy-related charges, and a nice corrections officer put them in the same room. And every morning, they would climb up to the top bunk and look out the window at the sheriff's deputy who's responsible, a woman who's responsible for arresting more of them than anyone else, and just shout expletives at her in the morning. Anyway, they all know somebody who's been arrested with this. And so all of this is to say that when you think about child or fetal protection, putting their mother in jail, denying her prenatal care. There was another woman who pregnancy justice represented who, or added to their case, who was denied medical care for premature ruptured membranes, was admitted to the hospital after many refused medical requests, and wound up having a stillbirth that may have been prevented if she had been able to access medical care earlier. So these women are being made examples of bad white women who are not reproducing in a socially sanctioned way, and even if it costs, it's obviously punitive against the pregnant people, and even if it has this negative effect on the children that they're, and the fetuses that they're supposed to be protecting, making a public example of them is still the overwhelming interest here.
Right, the spectacle, because it really isn't about them. There's a point I'd like to add to that, which is that if you look at the earliest laws that criminalized pregnancy, that criminalized abortion, in Roe, which is a 7-2 opinion, so it's not a close opinion, and that's always an important level set, right? It's 7-2, 5 of the 7 justices are Republican appointed. Justice Blackmun, who writes the opinion in Roe, was put on the court by Richard Nixon. This gives you some sense of the distinction between now and then and the shaky kind of narrative that this has always been a kind of ethos of a particular political party, which has not been. Even Planned Parenthood v. Casey was actually saved by those who had been Republican appointed on the court. Justice O'Connor put on the court by Reagan, Justice Kennedy, et cetera. But the criminalization of abortion itself was not at the time of the landing of pilgrim ships here. You know, abortions had been performed for millennia. They had. But to your point, Erin, abortion only begins to be criminalized in the United States at the drumbeat up to the Civil War. Something that we're hearing about today, this notion of replacement theory, too many brown people in this country, the browning of the United States, this nervousness about it. Anti-abortion laws only begin to appear in the mid-1800s, at a time in which the fever pitch for abolition is growing so strong. The literature about it, the narratives about it are so strong that this is a system that must come to its end. And it's at this time that then strategically there's a literature, there's a movement, some of it being led by the new obstetricians and gynecologists, which is a newer field. It's not a field that's been around for millennia. Nearly 100% of reproductive health care in the United States had been performed by women. Shouldn't be a surprise. You know, 1,000 years ago, there were not men walking around with stethoscopes and white lab coats all over Africa and Asia and Europe. They didn't exist, they didn't. And then many of these men were insecure because the doctors and the hospitals that existed in the United States before the obstetricians and gynecologists were considered schools of anatomy. And the people that were the real doctors were the people who were anatomists, the people who study, you know, where's the heart, where's the liver, how does it function? And these were people that were telling these guys, and they write about it, Horatio Storer and Joseph DeLee, they write about being made to feel insecure about what they're doing because the anatomists are telling them, you're just doing women's work. What's so special and fancy about you? 50% of the midwives are black women, many of them enslaved. What's so special about you as an obstetrician, as a gynecologist, this thing that you're calling yourself? And so part of the effort, it was a kind of multifold. One part of it was get rid of the midwives. If we can get them out of the way, we can be fancy too. And they're successful. We go from about 100% of reproductive health care being governed by women, which is not surprising, to at the turn of the 20th century, about 1% of the people doing reproductive health care are women. But the other thing that they're able to do strategically is that they lean into the American Medical Association. That's part of getting rid of the midwives, but they use the AMA as a lobbying force to help criminalize abortion, and they lean into white supremacy. They make a choice. Their choice isn't abolition. Their choice is, let's lean into anti-abortion, let's criminalize it, let's talk about this replacement theory and this fear of what's going to come if, in fact, the union wins and you get all these black people who are freed from slavery, who are going to then overwhelm the United States. And we see that same kind of fear in contemporary times.
And if I could just quickly jump in on the midwifery front, because that was the other reason that I was in Alabama, because there are people being forced to give birth in Alabama in a place where, depending on which list you look at, it's either number 1 or number 3 in terms of maternal mortality. And there are 3 people, all of which are black women, who are trying to open up birth centers that would bring back the midwifery standard of care. Alabama banned midwifery until 2017 and still has no legal birth centers. And so there was this trial where the ACLU was bringing a claim against them. And I told you this story off stage, and I just really want to share it because the Attorney General of Alabama, Steve Marshall, having already issued an opinion that said that anybody who helps somebody who'd like an abortion leave the state is committing criminal conspiracy and will be prosecuted, also had said that a doctor-controlled arm of the state would issue the regulations for birth centers. Okay, so, and of course, Alabama has a very strong pipeline of doctors running the public health department who are literally like the AMA of Alabama. And so they issue regulations, which anybody who remembers the abortion regulations that were put on clinics when they were still pretending they weren't banning abortion knows that they're very similar. They have requirements for these birth centers for midwives that they have to be 30 minutes from a hospital, that they have to have a doctor, blah, blah, blah. They're regulations that are designed to make them fail. And so one former abortion provider, Dr. Yoshika Robinson, and a midwife who is working in an area, the whole point is that they're very far from where there are doctors or hospitals. They're trying to provide options in a place where black women are obviously disproportionately likely to die in pregnancy or suffer severe morbidity, and a doctor in Birmingham as well. And so it's the Assistant Attorney General arguing this, and this is a white woman, maybe around my age, and I find myself in the elevator with her, and the whole time she's been doing this kind of like aw shucks thing. She actually said to the judge, I get so nervous in front of judges, and I Googled her, and it's like she's been the Assistant Attorney General for 7 years. I'm like, I see right through this act, I know this act. And so in the elevator, I introduce myself, I say I'm writing a book about pregnancy, and in the pre and post Dobbs era, and she asks where I've been, and I tell her that I've been in Etowah County focusing on chemical endangerment. And mind you, what's actually at hand here is that she's arguing on behalf of the state that these midwives and doctors should not be allowed to open up birth centers that would threaten doctors' control of these extremely poor birth outcomes in Alabama that disproportionately affect black women. And she says to me, oh, that's so interesting, okay, you're gonna focus on that. Are you also focusing on what the drugs do to the babies? Or are you only interested in the moms? And I was just so stunned because this changing the subject from the torture of pregnant individuals in Alabama for the sake, supposedly, of their babies. And I wish I had said to her, you know, is jail good for the babies? Their mother being in jail good for the babies? But I just said, well, I think that they're very linked. And she said, I wish I could talk to you more, and she walked away.
I love that story. We've got just a little bit of time left before we shift over to the Q&A. So I wanted to ask you guys, all of you, where you're seeing hope. We can end on a good note. Like, I certainly see hope in all of your work, for which I really want to thank you. But where are you guys, what's the silver lining?
I'll start. I guess I see hope from the fact that people are very activated right now. Everybody, you know, folks who, I mean, Roe has always been hanging from a thread. Like, even in 1973, when the case was decided, it was hanging from a thread because, days after the opinion was issued, you know, anti-abortion folks began dreaming up ways to limit it with the hope of eventually overturning it. So Roe has always been hanging from a thread. But the fact that, you know, Roe has officially been reversed has activated a lot of people. And so that sort of gives me hope, just the fact that people are thinking and doing and donating as well, and voting as well. What I would like to see is the linking of these, you know, abortion with all the other ways that, you know, reproductive oppression occurs in the U.S. I would love to see a more explicit linking between the coercion involved in, you know, forcing someone to carry a pregnancy to term and the coercion involved in denying them the ability to get pregnant in the first instance through environmental injustice, you know, produced infertility. I would love to see linkages between the coercion, again, involved in forcing someone to carry a pregnancy to term and the coercion involved in you know, forced episiotomies and forced C-sections in obstetric wards across, you know, the country. I would love for
are conversations about abortion, which have really been had under the reproductive rights framework, which is, again, abortion as a legal right, and then also a legal right as the Supreme Court has framed legal rights, meaning a negative right, the right to be free from governmental intervention, as opposed to a positive right, the right to have government assistance in realizing the stuff of the right. So a lot of our conversations around abortion have been under this very traditional reproductive rights, negative rights, constitutional rights kind of framework. And what I want to see is conversations around abortion being put under the reproductive justice framework, which is more than negative rights. It is positive rights, but it's also more than just abortion. It is the right to have a child, and it's the right to parent that child with dignity. And so if that's what we're fighting for, then it seems plain, right, that putting a person in jail for a substance use disorder, which the experts, don't identify as just bad behavior, but rather as like a medical condition. Putting someone in jail is an opposite to what reproductive justice requires. Letting people die as they go along this pathway to motherhood, to parenthood. Maternal mortality in the U.S. should be the stuff of national shame. Like, we should be embarrassed right now. And we certainly should be embarrassed about racial disparities in maternal mortality. So I hope you all are familiar that Black people are 3 to 4 times as likely as their white counterparts to die from a pregnancy-related cause, which means that the country particularly is failing Black people, but the country is failing white people too, because the rates of maternal deaths among white folks are higher than the rates of maternal deaths among 28 industrialized nations right now. So we're just failing pregnant people across the board, but we're particularly failing Black people who attempt parenthood, who attempt pregnancy, who attempt motherhood. So I would like to, what brings me hope is that people are activated about abortion. Put that in conversation with the fact that reproductive justice is out there. Black women have been doing this work since at least 1990, right? The reproductive justice terminology, if not the commitments, are on the tips of everybody's tongue. And so the fact that these things are coexisting in a post-Roe world makes it more likely that our struggles will be linked and that we can get everybody free and not just those who would want the ability to purchase abortion services in the market.
Snap. That's what the Garrett did. Yes, I know. I'm trying to get it. Yeah.
Michelle, how about you?
Well, I mean, I ditto, right, concur with everything that this brilliant professor next to me has just shared. In the wake of Dobbs, there has now been greater attention to maternal mortality and maternal morbidity in the United States. Just huge. I mean, if you think about it, it's incredibly cruel. It's cruel and unusual what states have done to people with the capacity for pregnancy, for women, girls, folks with the capacity for pregnancy. The statistics that you outline with Black women being, Black people being 3.5 times more likely to die, that's nationally. If we drill down to certain states, to certain counties, cities, right?
New York
looking
City.
at,
In New York City, it's between 8 and 12 times more likely.
This is the thing, right? I mean, it's just horrific. Internationally, we rank around 55th in the world in terms of maternal mortality.
I mean, to both of your points, I think it's actually, the disparity is less wide in Alabama because it's so bad for white women.
Yeah.
Whereas in New York, it's 8 to 12 times more likely to die for Black women.
You can't make it up. And so, in part, with the post-Dobbs era, it means bringing to light all of these other areas in which there has been suffering that didn't start just before Dobbs, but now that we get to have attention on it. But I will say a silver lining is the potential now to reshape the narrative along the lines that Professor Bridges just mentioned. But I also think about it in the following way. If we can think about the first Reconstruction as being the 13th, 14th, 15th Amendments, abolishing slavery and all that came with it, and maybe the second Reconstruction as being the 64 Civil Rights Act, Voting Rights Act, Medicaid, all those things, then we're time for another one combined with a justice framework. And what I want to think about, and I want us all to think about, is how we hold on to it. If we've had those moments of enlightenment before, then why did we lose it? Why have we let our guard down? Why haven't we been true marchers for freedom, equality, and justice such that we could fiercely hold on to it? And so my hope, the silver lining, I hope, coming out of these times is a sense that is unwavering and invulnerable to the tides that would make us slip behind.
Thank you.
Thank you.
And
I really don't want to have to follow that. I co-signed everything that the professor said. I think the only thing that I could add is that there's less gaslighting now than there was before. This was sort of implicit in what you were saying about Roe, but I think for those of us who also move in like political journalism spaces, or, you know, you could sort of get fooled about most law schools if you only met brilliant people like Professor Goodwin and Professor Bridges, because I've been to many legal conferences as a reporter and confidently heard that Roe would not be overturned. And that was even within the narrowest scope of conceptions of reproductive rights, that there was a complacency, that in politics there was a repeated claim that the Republican appointees would never do it because of the electoral consequences. It does give me hope that voters are activated in states like Kansas and Kentucky and Montana. It also gives me hope that there's already so much brilliant work being done here that now has an opportunity to be read by more people. We haven't mentioned one of the stories of our time post-Dobbs is the horrific, I use this word again, torture of individuals in emergency situations who are being denied care because of how abortion restrictions are putting fear in providers, people being forced to bleed out, to become septic, to sit in parking lots until they become sick enough to get care. Every one of these stories is a horrific tragedy, but it's also helping people understand another part of the scope of reproductive oppression, that what they consider the consequences of Dobbs is not just those women over there, those bad women who need abortions and don't want to be mothers. The right to refuse motherhood remains a core part of what we need to be talking about. We don't need to apologize and say, but these women wanted to be mothers. Nonetheless, they are being treated in a horrific fashion because of the ways that the laws are being visited upon them. I also get a lot of hope from the people that I get to talk to through my reporting, and that includes the people who are still working in these banned states, the people running clinics that they haven't relocated because they hope someday that they'll be able to reopen and provide a full spectrum of services. They're offering the services that they can, such as contraceptive care, prenatal care in maternity deserts, even very contested kinds of care like trans care, miscarriage management for folks who might be self-managing their abortions. It gives me some hope that there are options for people to get abortions on their own that are not as medically dangerous, if legally dangerous still, compared to, you know, if you go down history's path of all of the horrific ways in which people have felt desperate and had to try to end their pregnancies by themselves. Science has given us a safer way, so I feel some hope that actually what the statistics can measure, that in fact the abortion rate slightly went up after Dobbs, and that drives the anti-abortion people crazy. But I do think that it's a moment of clarity, and it's an opportunity for people who care about this stuff but may not have fully understood the breadth and the depth of it to listen to some of the smart work that's already being done, like by these folks here, and by people on the ground who, amid just astonishing barriers, ostracization in their communities, death threats, the difficulty to even open up an institution that provides birth care in a patient-centered, respectful fashion, that is a barrier in a so-called pro-life environment, I think really speaks volumes as to what's really happening here. And so I get a lot of hope from the fact that they're pressing on. You know, I'm just writing about it. that they're pressing on and they're living this every single day. And I think that anything that we can do to support that kind of work that's happening in the most hostile places, and in New York, where people have had their children taken away from them for testing positive for a legal substance, marijuana, I do think that being introspective about what's happening in blue states obviously needs to, I would like to see even more of that now.
Thank you all so much. Can we have a quick round of applause for them? Because I'm so grateful for them to join us. We have some wonderful questions from our audience, and I'm going to start with one. From a biologist's perspective, the associations between illegal drug use and miscarriage or stillbirth, as prosecuted in cases like Brittany Poolaw or Regina McKnight, seem so scientifically spurious, it is stunning that they stood up in court. How are these supposed cause and effect relationships demonstrated in court, if they are? And is there a role for biomedical scientists to help protect these people?
I'll jump in really quickly. There is, and I'll say that Dr. Claire Coles, who is at Emory, has shared with me that one of the ways in which she was able to help stave off the Georgia legislature from doing much of what was happening in states surrounding Georgia was to bring her medical evidence and her team to legislators and to be able to show them, like, look, you see this, what's happening in North Carolina, South Carolina, et cetera. Let's not do that here in Georgia because it's not real, it doesn't pan out. And so there is a lot to be said about researchers taking their work straight to the legislature, but then that also one has to be mindful that a lot of this, it doesn't matter, right? I mean, it should matter.
Yeah.
It should matter, but it ultimately doesn't matter. I mean, ultimately with Regina McKnight's case, she's a 23-year-old farm worker who shared with her medical providers that she had used an illicit substance during pregnancy. She had had a stillbirth and was charged with murder. Had a 20-year sentence that was reduced down to 12, and ultimately she was able to prevail, but only after having served almost most of that term before the court threw it out, basically for the weakness of the science that was used in prosecuting her. If you think about Dobbs as being outcome determinative, here's a goal in mind, and we're going to reach this goal. We're going to reach it however we need to reach it. That's one of the things that we're seeing with some of these prosecutions. And then what's happening, Alabama Supreme Court was exactly that in terms of what you were talking about, where the Alabama Supreme Court says we see no difference between a 12-year-old and a fetus, and we see no difference between a viable fetus and a non-viable fetus. So you're basically saying a 12-year-old is the equivalent of a fetus that's been gestating for 4 weeks.
I will also add that the part of, so again, the science can't support most of the time that drug use has caused a negative pregnancy outcome. But you also have to keep in mind that a lot of these folks are being prosecuted when there is no negative pregnancy outcome, like when there is actually a perfectly healthy child. Nevertheless, they are being prosecuted for the risks that their drug use might have posed a child, a danger to their fetus come child. But one thing I want to mention is that part of the problem is a function of just the muscularity of the criminal legal system. So even though it will be impossible in most cases for a prosecutor to show causation, to show that drug use caused a stillbirth, or show that drug use caused a miscarriage, or show that drug use caused low birth weight, the violence of the criminal legal system is that a lot of times prosecutors have so much power in terms of charging. They have the ability to charge first-degree murder, which would, put somebody, in jail for the rest of their life. And when you're facing such a charge, you're more likely to plead. Yeah, I'll plead. Fine, I'll do manslaughter. And then they're still facing 5 years in jail, even though the prosecutor's case is weak because causation can't be demonstrated. So part of this is so again, talking about linking struggles, I would love for our struggle for reproductive autonomy, reproductive justice, to be linked to a struggle against the violence of the criminal legal system. The fact that we we have the longest sentences in the world for criminal behavior, the fact that we turn to the police and prosecutors in prisons, in probation officers, when we're faced with a problem. Like when we're faced with a social problem, we're faced with the, people are hungry and they're stealing food, arrest them. People are harming others, they're hitting them over the head, arrest them, put them in jail. Like we turn to the criminal legal system when we have a social problem. And so when people are using substances while they're pregnant, of course, we have path dependence. We turn to police and prisons and prosecutors and probation officers. So again, our struggles need to be linked. It can't just be about reproductive justice in the sense of, are you able to have a child on your own terms? It has to be linked to just the muscularity of the criminal legal system in the U.S. as well. Yeah.
Thank you.
I just want to add two very short things. One is that Lynn Paltrow, who I mentioned before, always likes to say that if these banned substances were abortifacients, she'd be mailing them to banned states. It is just simply not the case. But when we're talking about how little the system heeds medical evidence, one of the cases that I came across in Etowah County was a woman who was arrested and jailed for a full day because her child, in a civil child protection proceeding, her child told the officer that she was pregnant. Nobody tested her for pregnancy. They only tested her for drugs. They arrested this woman for chemical endangerment of a fetus when she was, it turned out, not pregnant. So they took a child's word. I mean, and she's suing them right now. But she went through and you talked about the spectacle, mug shots, press releases, Facebook mug shots, everything. Not even physically possible that she committed this crime that she was accused of, and it was still paying that cost, paying that price.
Our next question, I think, might be a little bit thematically related. Talk about conceptual intransigence, right? I recently heard the argument that regardless of whether abortion rights were argued under the right to privacy or equal protections, the conservative Supreme Court would have found a way to strike it down. Do you see any viable strategies within the judicial branch or the other two to more permanently protect their right to abortion? Or does it seem like the anti-abortion folks are beyond reason and too powerful for an argument before the court to possibly succeed?
It's for you too.
I laugh. No, I laugh.
Yeah, no, I mean, to think about what the court did in Dobbs, it was the first time that the court took away a right that had been established. The court ignored decades of precedent. I mentioned earlier the case Skinner v. Oklahoma. If you toss that in, because 9-0, the Supreme Court ultimately struck down this law, saying that we'll treat it distinctly, a poor person, wealthy person, and crime. And so in 1942, you have the United States Supreme Court saying that there is a civil right to determine your own reproductive future and destiny, and that the state may not interfere with it. Now, it's a case that involves a man. It doesn't involve a woman. So it's 30 years later that we've got Roe v. Wade. But if you look at that altogether, it's like 80 years of precedent. The Supreme Court just tosses it out. The Supreme Court says, well, we have to look back, at things old, super old. Let's go old.
Older than that.
Older than that, right? Like really, really old. We need to cite people who never stepped foot in the United States. Sir, William, Hale and Blackstone and whatnot. We need to cite people who said the following about women, that married women lack independent personhood. We need to cite people who said that not only do women lack independent personhood once they are married, but individuals who said that there is no such thing as marital rape because a man cannot rape himself, and if you're a married woman, you have no independent identity. The Supreme Court cited male scholars from a long time ago to uphold striking down Roe, who supported that there was no such thing as domestic violence. That as long as, and they didn't do this part, but the whole point of domestic violence being something that was non-existent is part of the thinking that there is a rule of thumb. And so long as what you're beating your wife with is no thicker than your thumb, then it's legally permissible. This is the kind of characters that the Supreme Court rolls out to say that Roe should be overturned and Planned Parenthood v. Casey. So is there a cynicism then? I think the court has its own cynicism. I mean, it's a case where Justice Thomas has been saying that, look, eugenics, is really about black racial suppression, and that eugenics was really about black people. Now, it is true that later on there are these sterilization efforts against indigenous people, black people, et cetera. But I think one of the most obvious aspects of cynicism of the court is that in 1927, in that Buck v. Bell case, Justice Oliver Wendell Holmes tells us who Carrie Buck is. He says she was a poor white girl who was 16 when she got pregnant. So the very fact that this Supreme Court is like, oh, eugenics, that's about black people, when it's your own record. It's your own case. Did you not read your own case so that you could see in 1927 this is about white people, about poor white girls? Where are you making up this fiction about this is about, suppressing the black community and all of that? It's like nonsense. And so is it outcome determinative? Yes, it is. But I will say this one thing, which is the following, which is that there have been a lot of efforts to think about reforming the court for many different reasons. A lot of it has to be corruption on the court. But I think that there's a lot to be said about expanding the lower courts, which is something that President Jimmy Carter did, right? And I think that there's a lot to be thought about with the district courts and also with the courts of appeal. And I think that that's one space for us to be thinking about. I do think that these referenda are making a difference, that we see in Kansas and Kentucky and California and all of that. And that's making a difference as well. But one other thing, and I'll end with this, is to say that so much of this is like incremental. I wish it weren't, but it is. Just as one might think about the courts, we need to think about school boards. Who's sitting on the school board? Because right now across the United States, there are kids that are being denied sex education in this country, where the United States leads all of the industrialized world, air quotes, with chlamydia, gonorrhea amongst kids. I mean, like all of the horrible things that are happening to kids because we're not paying attention there.
I'll just add that second ditto, everything that Professor Goodwin just said. So the idea that we just need to come up with an argument, a really good one though, like a real slick one, and then the court will recognize people's reproductive autonomy. Then the court will start handing down these decisions that are consistent with reproductive justice. I think that it's not the way that the court has ever operated, and I think that what the court is doing now is just showing just what a partisan institution it is. As my very wise dean once said a couple of weeks ago, he said, I think nevertheless it's important to show that the emperor has no clothes. I think it's very important to show that these decisions are outcome determinative, that this is motivated reasoning, that they're inconsistent with one another. Right? They like on their right, exactly. So let me just briefly explain an inconsistency. Like when we were talking about Dobbs, when Dobbs was handed down a couple summers ago, and everyone was like, okay, what is originalism? Because that's what it seems like the court is into. The court is into originalism, and so we have to look in 1868 about what people were thinking, and what people were thinking in 1868. Well, that's what the Constitution protects, and it seems like there was evidence that people weren't thinking that the Constitution protected abortion rights, and so therefore the Constitution today doesn't protect them. So originalism, that seemed to be the court's thing. And then just this last term in Students for Fair Admission versus Harvard, the court interpreted the Equal Protection Clause as prohibiting race-based affirmative action. Now, originalism, if that's the court's thing, would suggest that we need to go back to 1868 to see what people were thinking about race-conscious programs that were designed to bring black people into the polity as equals. And had we looked in 1868 about what people were thinking around race-conscious programs that were designed to bring black people into the polity as equals, we would see they probably thought it was cool. I mean, this was the same, period in American history in which the Freedmen's Bureau was enacted. It was formed. It was designed to give black people food, clothing, shelter, health care in order to bring them into the polity as equals. So again, an originalist reading of the Equal Protection Clause would seem to demand a holding that race-based affirmative action programs are consistent with the 14th Amendment and are constitutional. Do you guys think that the court looked at what they were thinking in 1868 when interpreting the Equal Protection Clause? Of course not. There is no mention at all about what people were thinking in 1868 in Students for Fair Admission versus Harvard. The emperor has no clothes. There's no principle that would explain why we need to look to 1868 when interpreting the Due Process Clause, but not look to 1868 when interpreting the Equal Protection Clause.
And can I just really quickly,
Yes,
because I
please.
thought that you were going to just talk about the day before. So you've got
Bruin, go ahead.
Dobbs, and the day before you got the Bruin decision, the gun control case,
Yeah.
where the Supreme Court strikes down a New York law that is over a century old, that is about protecting the citizenry through a gun control measure. But what's interesting about the Bruin decision, Justice Thomas writes that opinion. And in that opinion, Justice Thomas says, and he actually says this, a prologue is necessary for you to really understand how important it is that Black male bodily autonomy is protected. And I need to give you a 5-paragraph prologue about examples of where Black male bodily autonomy wasn't protected, but it could have been protected with a gun. If they had a gun. There's the music professor, there's the mathematician, there are these different men, Black men, who needed their bodily autonomy protected, and if they had a gun, they'd be able to protect it. One day later, he writes a concurrence in the Dobbs decision. There is no mention of any prologue that's necessary for Black women. Black women don't need a prologue. Black women from Mississippi don't need a prologue. They don't need anybody to recognize from the Supreme Court anything related to their bodily autonomy in a state that rivals, that fights to be number one, not just in this country for maternal mortality, but in all of the industrialized world. And nothing coming from the majority ever even mentions Black woman or Black women. You will not find those two words together in the Dobbs decision at all. Black woman or Black women. And just the day before, it deserved a prologue for Black men.
And just one sentence to add, the arguments were made.
Oh,
And these two were among the many people who were making brilliant arguments about equal protection, about the historical subjugation of Black women's reproduction. Did they read them? If they read them, they disregarded them, and they did not, the majority obviously, and they did not listen to the core of the argument. And so I think that it's certainly not for lack of trying to put the best arguments in front of them in the form of amicus briefs or the main briefs in the case.
There's a lot of opportunities for freedom, but we should not be looking to that leadership from the court. We should be looking to it from the likes of you. I wish we could get to all of our questions. We have some really wonderful ones that I couldn't ask, but I want to thank you all for being here. And to thank our 3 panelists, please give them a hand, because they did such a wonderful job. Thank you so much.